Welcome to Grow Money Business, the podcast dedicated to helping business owners optimize income, pay less in tax, and invest prudently. Here's your host, Grant Bledsoe.
Hello, everybody. Grant Bledsoe here. Welcome back to Grow Money Business. Our guest on the show this week is Kenny Dettman. Kenny comes back on the show this week to tell us all about the Corporate Transparency Act. Kenny was a guest here a few months back and enlightened us on the Employee Retention Tax Credit, which the IRS has cracked down on since his interview, thankfully. But he comes today to tell us about the Corporate Transparency Act, which is a piece of legislation passed kind of under the radar back in 2021 when everybody was focusing on COVID, but will have wide-reaching ramifications in 2024 when the regulation becomes effective. Basically, any business with less than $5 million of revenue is going to have to file a new beneficial owner's information report with FinCEN, which is the Financial Crimes Enforcement Authority. So Kenny joins us today to tell us all about the act, who's eligible for it, who is exempt from it, and what the reporting requirements will be. And at the end of next year, if you're supposed to file one of these reports and you don't, the penalties are pretty stiff. $500 a day for noncompliance with a limit of $10,000 of fines for not having this reported. So as you can imagine, there are a whole bunch of businesses across the country that fit that category of having less than $5 million of revenue. And the estimates are that this bill will impact somewhere between 30 and 50 million businesses. So make sure you're aware of it. We haven't heard a whole lot about these reporting requirements yet. Kenny comments that the federal government has not done a great job of community outreach and publication, but rest assured, this is a thing you will need to comply with it starting next year. I really enjoyed talking to Kenny. He's very articulate. He's great at explaining these technical tax and other regulatory nuances. And he was certainly helpful for me to understand the situation. I enjoyed the conversation, and I hope you do as well. Hey everyone, I need to interject quickly to remind you all that nothing found in today's episode or any other episode of Grow Money Business should be considered financial, investing, legal, tax, fitness, or even relationship advice. It's content that you're free to use and to deploy on your own terms. And before taking any actions on content found on the show, please do consult with your tax professional, your attorney, or your financial planner. If you don't have a financial planner, head on over to threeoakswealth.com to learn more about what we do in terms of financial planning and investments and how we help clients on an ongoing basis. Kenny, welcome back to the show. I think you have the distinguished designation of being one of the few repeat guests we've had on the show. We're maybe 4 years into it, but our last interview a few months ago was so good that I am thrilled to have you back and enlighten us on some more tax stuff. Welcome back, and I'm looking forward to chatting.
Thanks for having me, Grant. Yeah, I've turned into a bit of a serial entrepreneur after my recovery from my days as a tax accountant. So this may not be the last time you have me on my show. So it's a real treat to be here. So thanks for having me.
Right on. You had a bunch of cool projects kind of in the hopper last time we talked, and I'm looking forward to hearing how all of those are going. You're back from paternity. Congratulations. First child, little girl. We were just chatting about it.
Absolutely.
And you took the shortcut of getting a night nurse, which I'm thrilled to hear too.
Total game changer. If you want to have a podcast on the benefits of a night nurse, I'm happy to do that as well. Highly recommended.
So today we want to focus on the Corporate Transparency Act. And as you were just explaining to me, and I know a little bit about this, I know there's some filing requirements coming up. I don't know the genesis of it. I don't think our listeners probably know the genesis of it. I would guess that most of our listeners have not even heard of this thing, but it is going to create a pretty big additional to-do for small businesses starting next year. Why don't we start from the beginning? Could you describe what this is and why it exists?
Sure, absolutely. So the Corporate Transparency Act was passed back in January of 2021. So, this is, if we take ourselves back to January 2021, this is hot off of the American Rescue Plan going live, which was the second stimulus bill. This was after the FDA emergency approved 2 out of the 3 major vaccines. People weren't paying attention to what was going on with non-COVID related legislation. And so the Corporate Transparency Act kind of snuck its way into a defense authorization bill for fiscal year 2021. President Trump actually vetoed the bill. It was overridden by two-thirds Congress vote, which sort of says, oh, this garnered bipartisan support. But largely, it's kind of been explained that the Corporate Transparency Act was so far in the deep into these bills that Congress really wasn't paying much attention to them. So there are some out there that said that this one really slipped through the cracks. So signed January 1st, 2021, it gave rise to a new reporting obligation called the Beneficial Ownership Information Report, or what we're casually calling the BOI report, that goes live in 2024. And the purpose of this reporting is for the federal government to collect information about the ownership, whether that's direct ownership or indirect ownership, of LLCs, corporations, other types of vehicles that are potentially being used to perpetuate money laundering, perpetuate tax evasion, perpetuate terrorist funding. So this was a data collection. This will be a data collection exercise across virtually all companies in the United States that don't meet very, very limited exemptions, for them to report to the federal government about who owns these entities, and also information about the owners of these entities. So there is, some personally PII that is going to be required to be reported with these forms. And the report goes to FinCEN. FinCEN is the Financial Crimes Enforcement Network. FinCEN is a bureau of the U.S. Treasury. It is not an organization that many business owners would be familiar with. Who is familiar with FinCEN? Banks are familiar with FinCEN. FinCEN is what puts the onus on financial institutions to be responsible for adhering to know your customer rules and anti-money laundering rules. So largely the effect or the influence of FinCEN has been felt by financial institutions, not by mom and pop business owners. The other reporting obligation that some folks that are familiar with FinCEN are aware of is something called a foreign bank account report. If you're a U.S. person, a U.S. taxpayer, and you have funds that are held offshore in offshore bank accounts, there is an annual obligation to report to FinCEN about on accounts over $10,000 in value. The other place you might have heard of FinCEN is that they were casually mentioned on an episode of Ozark. FinCEN was mentioned in the movie The Accountant. But my bet is that most of your listeners are not readily familiar with FinCEN, have not interacted with FinCEN. So this is a new reporting obligation to an organization that is not the IRS. It's a federal reporting obligation. Business owners are used to reporting to their state, and they're used to reporting to the IRS. All of a sudden, 2024, new obligation to FinCEN. I think it's going to really blindside a lot of business owners to learn that they are in fact obligated to file this form.
This is very interesting. So this is a piece of legislation that was thrown in kind of under the radar, along with a much larger piece of legislation. You used a framing that it was kind of thrown in at the last minute, and tried to the originators of these requirements, the writers of this portion of the legislation tried to push one past the goalie quickly. What are the motivations? What's the argument for having this, and who wanted it in the legislation in the first place?
It is a little bit wild to think that the United States federal government nor the respective 50 states are collecting information about the ownership of legal entities in the United States. So, as of today, you can still form a Delaware limited liability company and not tell the state of Delaware or not tell the federal government about who owns the LLC. Corporate transparency, beneficial ownership information reporting is actually something that's very prevalent across the world. Today, even in the Cayman Islands, in the BVIs, where you used to be able to kind of discreetly and anonymously hide money offshore, they have BOI reporting. So the intent, the reason behind this legislation is to try to deter bad activity, nefarious activities that are promulgated by being able to stay anonymous with a U.S. LLC corporation or other type of corporate entity. So the intent is I would say it's a good intent, but the fact that it's really going to dramatically affect mostly businesses that are not intended to perpetuate nefarious activities, and the penalties are quite steep. So to sort of restate the answer, it's to bring the United States in line with what the rest of the world is doing regarding transparency. It is going to capture virtually all businesses, all companies in the United States that don't either meet a $5 million revenue threshold or not otherwise very highly regulated. So our estimation is 95% of corporate entities in the United States are going to be subject to this reporting. That number probably will increase once we start talking about the different types of exemptions. And I think we're going to find that a lot of entities that are kind of on the fence as to whether they qualify for these exemptions will just decide to proactively file.
Interesting. So this is something that the rest of the world has been doing for a long time. It seems legitimate that we should have some kind of database or reporting so that the government does know the actual ownership of LLCs and corporations in the country. Currently, we don't have that. So it's, to me, at least off the cuff, it seems like a legitimate thing that we should probably have. But in order to get it passed, they had to slip it under the radar because I'm guessing people on the right side of the aisle who want smaller government and more business-friendly environment are pushing back against that. Is that a fair characterization?
That is fair. I'll give you an example. In the United Kingdom, you're able to search in something called Companies House. You can go online, you can search any legal entity, and it's going to give you paperwork that shows every single owner, and you can keep following the chain of ownership if you're talking about multi-tiers of ownership. With the beneficial ownership information reporting, this data is not going to be publicly accessible. The federal government is going to possess and safeguard this data. To some extent, it may be shared with financial institutions. What would be the purpose of that? Well, financial institutions, as of today, are required to follow regulations under FinCEN to make sure that they understand ownership. So this is sort of a cross-reference. So banks are doing this on their own. The federal government is now going to start independently collecting data about legal entities, and the ability now for banks to cross-reference, to check what they've discovered through their own procedures against what's self-reported by companies creates a valuable tool for identifying situations where things potentially don't look as they should seem.
Right. And if you're back there listening to this and you're of the opinion that the government needs to stay out of my business, there's no reason for us to be reporting that. I get that, and ordinarily I kind of feel the same way. But here's an argument in favor of this too. You think back to the Paycheck Protection Program, right? Where the government is just handing out checks in huge quantities, and there has been so much rampant fraud that the government has no way of knowing whether it's a cartel operator from Mexico or somebody from Iran or Saudi Arabia behind an LLC, or whether it's a legitimate U.S.-based business that's taking out this free money that the government is handing out. Right? This is a pretty basic thing that we should probably have some infrastructure around.
Yep.
So it got passed because their eyes were on COVID-related things. now we have to start to adhere to this next year. Who needs to pay attention to this and who is exempt?
Okay, so there's three important definitions that we'll talk through. The first is a reporting company. A reporting company is a company that's required to file. The second definition is a beneficial owner. So once we've established that we have a reporting company, who is the reporting company required to identify as a beneficial owner and provide information on behalf of? And then the third is a company applicant. Company applicant is only applicable to new entities that are formed after January 1st, 2024. And in short, it describes the lawyer or the paralegal or whoever was involved with the actual formation of the company. So a reporting company is broken down into two different categories: domestic reporting company and a foreign reporting company. A domestic reporting company is going to be a U.S.-based LLC, corporation, or really any type of company that files paperwork with a Secretary of State to establish its existence. This could also include general partnerships, which are not legal entities, but still file paperwork. And this also would include potentially tribal organizations. So reporting company is what we think of: Delaware LLC, California Corporation, Florida nonprofit. These are reporting companies until or unless they find themselves exempt. And we'll talk quickly through the exempt categories. A foreign reporting company is quite obvious. This is a foreign company that has registered with a Secretary of State to be authorized to conduct business activities in that state. Think of a Cayman Limited Partnership that registers with the state of Delaware to source capital through a raise. Or it could also be I'm from South Florida. We have lots of South Americans who establish Florida LLCs for the purpose of holding U.S. real property. In some cases, they're actually registering their foreign limitadas or other vehicles directly in the state of Florida, as opposed to establishing a domestic entity. So domestic and foreign reporting companies, what are the exemptions?
Can I ask a quick question first?
Absolutely.
You mentioned organization for domestic entities, organizations that have to file paperwork with the Secretary of State. I'm assuming that your sole proprietors are not included in that group. What about partnerships?
Sole proprietor that is not is truly a sole proprietor and not a single member LLC is not required to file anything. You can't own yourself, or I suppose you could, but the federal government doesn't need to know about the ownership of a sole proprietorship that's established as a DBA. That information is easy to find. It's filed with the DBA applications. A partnership, whether it be a limited liability company that's a partnership for tax purposes, or a limited partnership, a double LP, a triple LP, absolutely. They all file paperwork with the Secretary of State to establish their existence.
Gotcha. So you were, before I interrupted you, about to explain exemptions.
Exemptions, there's technically 23 categories of exemptions. I break them down into 4 more simplified categories: large operating entity or large operating company, greater than $5 million in revenue, more than 20 full-time employees, has a U.S. physical presence through an office or a warehouse, and files a U.S. tax return. Not the overwhelming or anywhere close to the majority of corporations or LLCs in the United States. The second exemption would be for an inactive entity. An inactive entity would be truly dormant. It's not a holding company that's got, an operating business below it. We're not expecting this to be a very expansive exemption. This is going to be an LLC that was set up that somebody abandoned the purpose of conducting activities through it, or perhaps a LLC that sold off all of its assets and just wasn't wound down. So not expecting a great volume of inactive entities. Then we get into what I described as highly regulated. These are banks, insurance companies, registered accounting firms, so public accounting firms, public utilities, nonprofits. These are organizations where the federal government is already collecting enough about them by virtue of other regulations that it really isn't necessary to net them into the Corporate Transparency Act and the BOI. And then the last category is subsidiaries of any of these 3 categories. So if you're a subsidiary, if you're a controlled member of a large operating company, then you're exempt. The one very important exemption on the subsidiaries that doesn't apply, if you think about most private equity funds, venture capital funds, family office vehicles, they are typically going to fall within the category of a highly regulated under the definition of a pooled investment vehicle. So they're pooling, investment capital, and they're deploying that into portfolio investments. Their subsidiaries are not exempt. So yes, the fund itself, maybe the top vehicle that's pooling capital is exempt. The investments of that do not fall within the exception for subsidiaries. So that is reporting company.
Interesting. Okay. So this is going to impact a whole lot of businesses across the country. What are the estimates on the number of impacted organizations?
So currently, FinCEN is estimating somewhere between 30 and 50 million businesses will be affected in 2024 when the reporting obligations go live. So you're going to have the reporting obligations that we'll talk through deadlines are broken up into two categories. One is pre-existing entities. So if you came into 2024 as a corporation or an LLC or otherwise a reporting company, you are a pre-existing entity. If you are an entity formed after such time, you're a new entity. And they're estimating around 5 million new entities will be caught into the BOI net, and somewhere in the 30 to 45 million company range for pre-existing entities.
Wow. So what are the reporting requirements then? And if there's a huge difference, I would think that if you're considering something new in the next year, you might want to get around to forming before the end of the year so that you can qualify as a pre-existing organization.
It's only a mildly augmented obligation if you're a new entity. So we'll talk through the distinction. Before we get there, let's talk about what's a beneficial owner. So now we have a reporting company. What do we need? What do we need to report? We need to report pretty simple from the company's perspective: the name of the company, DBA, address, employer identification number. Not a heck of a lot of information. There's no financial data that's shared. Now let's talk about beneficial owners. A beneficial owner is determined based on either equity interests or control. And control can get very subjective. Equity, pretty black and white. And, for most companies, sometimes you're going to deal with different classes of units and different sharing of profit, losses, and capital. But they set the threshold at 25% for equity. So substantial from an equity perspective is greater than 25%. Now let's talk about control. Control is fairly expansive. It's surprisingly expansive. The FinCEN rules and the guidance today says that substantial control is going to include anyone in your C-suite. So chief executive officer, chief financial officer, chief operating officer, general counsel in many cases. These are not folks that are used to being identified as being substantial, the equivalent of substantial equity holders. Members of your board that have enough influence to control who's on the C-suite, those are also going to be substantial control owners that are beneficial owners. And then there's really a catch-all category, sort of at the bottom of the FinCEN's guidance. They provide some flow charts that are very useful. At the bottom is this catch-all of, anybody else who has substantial control. And they sort of loosely put control at a 25% metric, which is kind of wacky to say, does the COO have 25% influence? So there's some sort of blending of objective and subjective in these determinations. And so once you have determined who the beneficial owners are, which is not a simple feat for every company, you're reporting their name, their home address, which we know that, people don't really like provide. And anytime, you get a form that says report your home address and, you're sitting in your office as a business owner, you're often just saying, let me just put my business address. They don't need to know, where I live. So that is a statutory requirement to provide your home address, your date of birth. And here's the really annoying one, a copy of your driver's license or passport. And if you imagine a company that has 10 beneficial owners, C-suite directors, equity. The exercise of having to go retrieve 10 different copies of passports and driver's license is going to be a pain. It's really not something your accountant wants to do. It's not something your lawyer wants to do. So it sort of begs the question of, who's going to be helping businesses comply with these requirements? And we'll get a little bit into the platform I've established to help business owners with the BOI reports. So now we framed the reporting companies, what they need to file, beneficial owners, how to determine who's a beneficial owner, what information is required to be reported by a beneficial owner. And the last definition we talked about was a company applicant. Pre-existing companies, January 1st, 2024 and prior, they are going to be they're going to be able to abstain from telling FinCEN who helped them form the company. But after January 1st, 2024, you are going to have to tell FinCEN the law firm that was involved, or in fact, the individual lawyer that was involved with helping you file paperwork to form your entity. And if somebody within the company was meaningfully involved in preparing the application or preparing the forms, they would be reported as well. And it's very similar information that they need to provide as what the beneficial owners need to provide.
Interesting. Okay. So with regard to decision makers, those with control, it's 25% of the equity or control. We're not talking about and, right? So if you have your chief legal in-house, legal counsel that exerts control but only has 2% of the equity, they're going on the report too.
Correct. So it's an or. You may have an operating business with $4 million in revenue, owned by one high net worth individual, and you think, oh, easy, we've got one beneficial ownership to report. Not true. There might be a board, and there's almost certainly a C-suite in that operating company. Now, all of a sudden, somebody on the company side, or maybe an advisor they hire, is going to be responsible for going out and collecting information from all of these individuals who are probably not overly keen on providing their home address and a copy of their passport or driver's license. This is a company level obligation. So it is the company's responsibility to file. Obviously, the company can't file a complete and accurate submission without the participation of beneficial owners. So another thing you're going to be seeing and hearing about is amendments to operating agreements or shareholder agreements that say that, if you are in fact, admitted as a member or a shareholder, that to the extent you are deemed to be a beneficial owner, you have to provide this information. We are going to see a lot of beneficial owners in 2024 saying, you know what, I don't want anything to do with this. This is your problem, company. I'm just a passive investor here. Leave me alone.
Right. Interesting. So what are your deadlines? What do you have to file? When do you have to have it in by?
So pre-existing companies have time. They are required to complete the filing by the end of 2024. So there's a full year and 2.5 months to file for pre-existing entities. For simple ownership structures, probably not something to treat as super urgent right now. But think of a family office or a private equity fund with, hundreds, if not thousands of legal entities in their structure. This is going to take a lot of time to analyze who's a reporting company, who's a beneficial owner. Do we have the information we need to report? So for more complex organizations, I'd say the sooner the better. So end of 2024 for pre-existing. If you form a company on or after January 1st, 2024, current legislation says that you have 30 days to file your beneficial ownership information report. FinCEN has just put out proposed regulations to stretch that to 90 days, but only for the purpose of the first year. This is a one-time filing obligation on its face. Once you file it, you're sort of in the clear. Well, that's not exactly the case. If any information changes from your original submission, you change your address, your driver's license expired, and therefore there's a different driver's license number on your new driver's license, you have to file again. You have to file within 30 days of a change of information. So, for for law firms, accounting firms, company formation businesses. They need to be paying attention to this right now. They need to set the infrastructure up because they only have 30 days under the current rules to help, their clients submit these BOI reports.
So what about now? I'm trying to remember back to the exemptions. If you have more than $5 million in revenues, then
5 million revenue, 20 employees, U.S. physical presence.
Okay, 5 million. If you've got more than 5 million in revenue, you don't have to worry about this. But a lot of companies in the $2 to $4.5 million range are going to have kind of a rotating base of ownership, making this kind of a constant thing to pay attention to. Yeah.
Oh, absolutely. I mean, think of a new entity that's formed with no employees, no C-suite. First thing you do is form the entity. You get the EIN, and then 3 months later, you start building out your C-suite. And every time you make an addition to your C-suite, you got to file again. In your example, absolutely, the rotational of C-suite, directors, and ownership. Every time something happens, 30 days. So there needs to be a real lean on technology here to make that to make both identifying a change of information efficient, and then also, of course, make the filing itself efficient. We haven't talked yet about the penalties. So, the beneficial owner says, I don't want anything to do with this. I'm a passive investor. The omission of the filing or filing an incorrect form, which would include an incomplete form because your beneficial owner wouldn't give you information, gives rise to a penalty. It's not a discretionary penalty. It's an automatic penalty of $500 per day that the filing is late, up to $10,000. If there is willful negligence, or there is, an intent to perpetuate fraud or provide false information, this does spill over from civil to criminal. So there are criminal penalties for willfully failing to file or filing, inaccurate or incorrect information. So while on its face you might say, this is an invasion of my privacy. This is the government overstepping their bounds. These penalties are, not something to take lightly.
I can sense hundreds, thousands of legal disputes coming over the next 18 months. If you're running an organization with a C-suite of 4 or 5 individuals, and your COO simply doesn't want to give out their personal address on one of these things, you don't really have a choice. If they dig their heels in, I guess you have to let them go, right? I mean, this is the business's responsibility, and this will absolutely come up for people. Yeah.
So I've seen this play out a little bit before with the foreign bank account report I mentioned. Yeah. So foreign bank account reports are required to be filed by U.S. individuals that have greater than $10,000 offshore, but also U.S. legal entities. So if a corporation has a subsidiary in Bermuda and that subsidiary has $10,000 in its bank account, that gives rise to a foreign bank account reporting obligation. And it used to be that you were only required to file these if you had an economic interest in the entity. You had an indirect economic interest. You own that underlying bank account. They changed that over the course of my career, such that signature authority also gave rise to having to file an FBAR. So you can have no economic interest whatsoever in the underlying bank accounts of the offshore funds, but if you had signature account authority, if you were a CFO of that U.S. multinational with lots of offshore accounts, now all of a sudden you get brought into FBAR reporting. What I can tell you based on my experience there is that FinCEN quickly realized they were probably getting too aggressive in what they were asking for and, in what period of time. So we did see with the case of the FBAR rules getting revised, FinCEN kept delaying the deadline, or they would keep the deadline, but they would waive the penalties. So I wouldn't encourage your listeners to, simply anticipate some leniency there. But I can tell you that I would not be surprised if we don't see some dramatic changes to how they're at least approaching the deadlines or the penalties in 2024.
Sure. And as you said, they're already drafting a proposed amendment to stretch it out from 30 to 90 days for new entities, right? So
yeah, which
a
is
little bit
really
of that
not
already.
much in a way for,
right.
And just for 2024. What sort of annoys me too about the rolling, 30, whether it's 30 or 90 days, tax nerds like myself, lawyer, like we're used to sort of fixed deadlines, right? We're used to things being due on the 15th day of, April, or the last day of the month.
Mm-hmm.
If you're a lawyer who's forming legal entities for clients, every day or every other day, now all of a sudden you have deadlines that are, all throughout the year, as opposed to a mid-month or a mid or an end of month deadline. So we're actually submitting in this proposal to move from 30 to 90 days. My organization is actually submitting some comments to FinCEN to encourage them to rethink of, the way this rolling deadline works. The suggestion would be it should be due either, on the 15th or the last day of, say, the month following whenever, either the company formation took place or the change of information took place.
Sure. Well, this is very interesting. If you're FinCEN at the end of next year, how are you going to go about enforcing this? I guess it would be pretty easy to compare the the list of EINs with a list of organizations related to those EINs that have submitted the documentation, and then just start with the gaps. How would you think about this if you're an enforcement agency?
Well, my initial reaction is there probably won't be much enforcement or activity in the early stages. I think when we compare this, and I'll compare it back to the FBAR again. The FBAR is where an individual or a company is reporting to FinCEN about the existence of offshore funds. There's a corollary piece of legislation called FATCA, the Foreign Account Tax Compliance Act. That's where financial institutions around the world, this is mostly applicable to non-U.S. financial institutions, are required to report back to their government and then indirectly the U.S. government about U.S. persons that are holding accounts with them. So you sort of have this, all right, we have the self-reporting system with the FBAR, and then we have the financial institution reporting system with FATCA. We should be able to cross-reference and find, irregularities or anomalies. As far as we know, there's not been much done with the data collected through FATCA. It takes the government, the government has the data. It's a question of what are they going to do with it? When are they going to do something with it? How, what technology, with the proliferation of AI, you would think that, there should be some methods for making this data useful. So let's bring that back to BOI and FinCEN. We're going the opposite. We already have the financial institution regulations. Now we're getting the self-reporting regulations. It will be, it will be interesting to see what FinCEN does with that data, how they use that data. The obvious thing would be exactly as you mentioned, to cross-reference it to other publicly stored data through BSA, the Bank Secrecy Act, through FinCEN regulations. So to be determined. I have a hunch that you're not going to see whether they waive the penalties or not. I don't foresee FinCEN taking a super hard line on organizations, businesses that miss this solely by virtue of just not knowing about it. So we always have something called reasonable cause in the tax world. It translates into other regulations in the FinCEN world. If you have a reasonable cause, imagine somebody who does their 1040 with TurboTax and all they have is an Airbnb property that they hold through a single member LLC. They don't have a tax accountant or a lawyer out there to tell them, hey, there's this new obligation that the federal government is not doing a very good job of creating education around. how do they know they're supposed to file the BOI report?
Right. And that was exactly what I was going to ask you next is, I didn't know about this until you mentioned it to me a few months ago. Why are we not hearing about this? Why would you would think that there should be a little bit more public engagement, public outreach, communication.
It's picking up. I don't know whether it was a formal obligation or sort of a soft commitment from FinCEN to work with the secretaries of states, right? That's where, if you're a legal, if you're responsible for a legal entity, you're typically filing an annual report with, your state division of corporations. So that's sort of the first place that you might look to for new or changed regulations. So FinCEN has said that they are or are about to start working with the state divisions of corporations or similar organizations to create awareness. The AICPA, by the way, is up in arms about this. They're saying this needs to be suspended. Not enough awareness out there. The other thing that's a little tricky with CPAs is that many state CPA boards are not comfortable that helping with this filing does not constitute the unauthorized practice of law. So CPAs are always really nervous about tripping the line and crossing into, oh, wait, I'm practicing law. Now your state CPA boards and their insurers are telling them, whoa, we're not sure yet. This might be crossing that line. So where do you look to? Do you look to your lawyer who charges you, $300 to $1,500 an hour to help you with this? It's a great question. And I am seeing more traction in the amount of thought leadership that's being put out there on this. But, until, the New York Times and the Wall Street Journal and, all the major media, outlets are creating awareness about this, I don't know that anybody's going to, have an easy way to find out.
That's unfortunate, but something that we run into semi-frequently when there's new stuff rolled out. Yeah. So you've been working on a couple side projects over the last, year or two, and one of them has to do with government filings directly applicable to the Corporate Transparency Act. Why don't you tell us about this?
Sure. So we have over the course of the last 12 months spun up a technology platform called File Forms. Simple name. That's what we do. We help business owners and operators and folks that are in the sphere of influence with businesses satisfy regulatory and statutory filing obligations. We are not a CPA firm trying to help with tax filings. We're here to help with annual reports, registered agent, foreign informational reports to the Bureau of Economic Analysis. But the flagship product that we're coming out with is around, you guessed it, the beneficial ownership information report. So File Forms serves as a third-party platform for business owners and operators to use to help them collect the information for filing the beneficial ownership information reports. And ultimately, when the FinCEN system is live, File Forms will submit these on behalf of the business owners. It is a TurboTax-like solution. It's step-by-step. It's easy to understand and manage. One of the core features is the ability for, if you're, imagine, you talked about a operating business with, say, $4 million in revenue, and let's imagine they have 10 different beneficial owners. File Forms enables what we call the company admin. So somebody in that organization is ultimately going to be the one saying, hey, we're going to make sure that this thing is filed and we're going to be responsible. Maybe it's the general counsel. The general counsel doesn't want to go around and collect information from 10 beneficial owners. So what File Forms enables the company admin to do is to send out push notifications for those beneficial owners to create their own profiles. And that information is not shared with the other beneficial owners. So there's some protection of information. There's ease of collecting, and in particular, the driver's license and passport, ease of collecting information. And then there's the ability to reuse that information. Let's say there are multiple entities involved in the structure you just described. There's a subsidiary below that. Now you've got two entities. Do you want to have to repeat the process from scratch to do the subsidiary? Absolutely not. So what File Forms enables you to do is reuse what we call the BO profile. So it's a much simpler system than we envision what FinCEN will put out there. We don't know because it doesn't exist. But I've got years of experience filing FBARs, and my money is not on FinCEN, investing a lot in UI and UX to enhance and improve the user experience. And one thing I'll add is the ease of filing that second or third or fourth instance of a BOI report is going to be much easier using a file forms versus using the FinCEN system. It should be as easy as going in, identifying where the change of information happened and pressing submit. Even better, file forms will enable a monitoring service. There is a database of all the corporate information across all 50 states that we hook into, and we look for those changes. So if we see a change, we're going to notify the company admin and say, hey, we noticed that in the state of Wyoming, you changed your address. You need to file a beneficial ownership information report.
Very cool. So is file forms live now with other forms businesses might need to get to the regulator, secretaries of state, regulators, whomever?
Today, file forms is 100% focused on the BOI. We are sort of slow playing the additional services. Why would you want to use file forms now as opposed to in 2024? It's to get your ducks in a row. We also offer early bird discounts. So if you use our platform now, you can prepay for the filing. You're also going to get a filing analysis. So as part of using file forms, we are going to provide you with a file that doesn't go to FinCEN, but goes in your desk drawer or your filing cabinet that establishes, why you're a reporting company, how we determined or how you determine who your beneficial owners are, summary of that information. It's effectively going to be, your backup in case FinCEN does come ask and says, how did you determine you were required to file? Why did you report these beneficial owners? So it does produce a bit of a bulletproof backup to substantiate the information that you did in fact submit to FinCEN or will submit in 2024.
Sure. So if our audience is mostly owners of smaller organizations, fewer than 15 or 20 employees.
Yep.
A lot of them are doing great revenue-wise, but certainly under the 5 million threshold that would make them eligible to have to submit this report starting next year. If you're in that situation, let's say that you have a business attorney that you have a relationship with, you have maybe a tax person or a bookkeeper, who should be talking to you about this stuff? Who should you expect to hear from?
You'll hear from your accountant, but they'll probably say, here's information, but we're not going to do this. Either A, because they're too busy. Accountants are totally spread thin, and this is just another thing that, they'll try to avoid getting thrown on their plate. They're worried about it being the unauthorized practice of law. And they're not interested in the admin of having to go, figure out who beneficial. It's not really an accounting test. Do they want to be chasing passports and driver's license? Probably not. So your accountant will probably let you know about it. If they do charge you for it, it's probably not going to be cheap. Simple information, but there's an increase in the there's certainly a shortage in the number of accountants. There is a sharpening increase in the hourly rates and the fee structures of good accountants out there. So expect to pay a meaningful amount for your accountant to facilitate this. And then the same goes with the lawyers. Is this really something that an attorney billing out at $300 to $1,500 an hour is going to be wanting to have to manage? So if you are fortunate enough to have a business that has a external counsel that is on retainer, sure, they'll probably let you know. But as you know, most of your clients probably don't just have some accountant who's an extension of the organization. Mm-hmm. So expect to potentially hear from one of the two, but then you've got your guys out there who are self-preparing their taxes and may have some LLCs set up for investment purposes. I'm not sure who's going to tell them.
Yeah. Well, hopefully you will.
Well, that's what we're trying to do is get the word out. And we've created a tool on www.fileforms.com, which is a free BOI qualification tool. It's free to use. It's going to take you through a 5-step questionnaire. And at the end, it's going to tell you whether you're a reporting company or not. If you are, in fact, a reporting company, you can choose to use FileForms now, or you can wait until 2024 when the FinCEN portal is open, and you could try to figure out how to do it yourself. We encourage that from a risk mitigation perspective, but also the perspective of being efficient from the out-of-pocket costs from the business owner. FileForms is likely going to be certainly the cheaper option to use as opposed to using your accountant or your lawyer.
Very cool. Well, this has been really interesting, Kenny. I appreciate you running us through the back to front of all this. What have we not covered yet that's relevant to business owners subject to this new filing requirement?
So we touched on this a little bit, but the amendments to, it's not just going to be amendments to operating agreements and shareholder agreements. As you were alluding to with your COO who didn't want to file, it's going to be amendments to employment agreements. This is going to touch a lot of legal paperwork. And so, in thinking through not just am I a reporting company, who are my beneficial owners, who's the company applicant, it's probably important to think about the universe of legal documents that interplay and interact with this. And so, that is certainly for more sophisticated organizations. They're really going to want to be paying attention to whether they need to amend prior legal documents, and certainly in drafting new legal documents, you're going to see Corporate Transparency Act and beneficial ownership information incorporated in new drafts of legal documents.
Interesting. Well, I appreciate your time as always, Kenny. This is great. I am 100% confident that this will make the Wall Street Journal here at some point in maybe the next few months, or perhaps at some point next year, hopefully. But we'll start to hear about it more and more thanks to people
Trust
like you.
I've been pinging the Wall Street Journal, so we'll
good. Good.
I've had a couple of interviews and was quoted in the Wall Street Journal earlier this year related to one of my other businesses, and I'm sort of trying to raise my arm up and say, hey guys, like this is important. This is whether you're doing it because you want good news, good press, or doing it because you also believe that sort of the right of the business owner to become aware of this before it goes live. Either way, certainly trying to get the word out.
So fileforms.com, did I get the URL right?
That's
fileforms.com. Where else can people follow you and pay attention to this stuff?
So I'm, as mentioned, a bit of a serial entrepreneur. So we've got a new tax technology platform out there called Tax Now. But the best way to keep track of what I'm doing is probably just to follow me on LinkedIn, Kenneth Dettman. And, I do a lot of thought leadership and post content there. And so you can find your way to FileForms, Tax Now, and my other business, Easy ERC.
Right on. Well, keep at it. You're doing great work, and I look forward to having you back on again in the future.
Sounds good. Appreciate you having me, Grant. Take care.
Thanks for tuning in to Grow Money Business, the podcast dedicated to helping business owners optimize income, pay less in tax, and invest prudently. Be sure to subscribe to the podcast on iTunes, Google, Spotify, or wherever you digest podcasts to ensure you don't miss out on future episodes and announcements, and feel free to submit questions to growmoneybusiness.com.